All right, guys, welcome to Legal Drafting Workshop 2. I'm very glad to see that some of you have shown up. I know that the task feels a little bit challenging this week because we're only in week 2 and already you've got to be thinking about how to identify weaknesses in drafting and then redraft a stronger, better clause. But we only get there through practice. Practice makes perfect. And so anything that you've done today towards that is still helping you learn new techniques, new drafting techniques. Okay, so I thought we could start off with a poll just to get an idea of how you felt about the task. And it's anonymous, so feel free to be completely honest. So the question is, how difficult did you find redrafting the clause for this workshop? So was it easy? Generally easy, but one or two aspects were difficult. Most of it was quite difficult, or the whole thing was very difficult. So identify where you fall within that. Just waiting for a few more. One more person to vote. Okay, so let's have a look. So we have, I'll share the results with you because they're anonymous. You'll find that nobody found it really difficult and nobody found it easy. So you're all in that middle band of it's either easy but some aspects are tricky, or most of it was tricky but some aspects were okay. So that's perfectly normal. Where you're at right now is exactly where you should be. You only know a little bit of information about drafting, but you're having to look at a big picture drafting exercise. Okay, hopefully somewhere between now and say week 6 or 7 that will change and you'll find that you move a band closer towards easy. So if you're in most of it was quite difficult, hopefully you'll go to generally easy, and if you're in generally easy, hopefully you'll go to easy in the next sort of 6 weeks or so. As you guys know, the first 4 weeks of legal drafting is really focusing on common drafting errors that stem from our use of language. But after that, we start to look at specific scenarios which have very specific requirements. So an outline of argument is very different to a letter to a client, for example. So we will be looking at those very specific requirements, but in the background is still all this week 1 to 4 information that we're learning. Okay, because that week 1 to 4 information is going to apply throughout every single week. So what we're doing is we're learning the essential skills right now, and until we've got 4 weeks under our belt, we will feel a little bit uneasy at times about drafting exercises. Okay, so I want to get straight into let me just close that. I wanted to get straight into the exercise because there's actually quite a lot to cover. Even though it's only one paragraph, there's a lot of things to discuss in it. So, but before we do that, I thought we could talk about our preparation and how we prepared the draft, what we did, what steps we took, what was helpful and what wasn't. So, who would like to start that off for us? Who would like to talk about how they prepared the draft?
Hi, Nicola. I can speak if you'd
Hi, Jan.
like.
Yeah, that would be
Hi.
great.
Okay, so what I did was I actually, so I went through the process of reading through study guide 1, and
Yep.
then, so I've just like outlined the components of what a professional writer would need first. So like the context, who the reader is, and things like that. And then what I did was I had a look at the text, and because it was just like freaking me out, I separated each sentence basically just to
Great.
sort of
Yep.
break it up. And then what I did was I had the old text, and then like the redraft right underneath it, and then I did my redraft. And I also organized the clauses, so the most important information was at the top.
Yep.
So
Great.
And I also broke it up. I've got the bank, so information regarding the bank, and then information regarding the merchant.
Okay, so in terms of their obligations, so you went, oh, the bank's obligations are these and the
Yep.
merchants, yeah, okay, great.
Yeah.
Yep, so
So
that sounds very logical in the way that you approach that. Definitely, I think a sentence at a time is important because we can't really, although we can't understand the whole clause without reading it from start to finish, what you can see when you break it down sentence by sentence is that there's usually one obligation in each sentence, sometimes more, but at least one obligation. So taking it like that helps you identify what the obligations are. You can then start to think about how you might restructure those. So in your instance, you went, okay, I'm going to split it into two categories, the bank and the merchant. But you
yeah.
would have had to have digested that sentence by sentence to work that out. So that's great. And that sounds like a really good start. Okay, so on the right track there. Anyone else want to share with us what they did?
Although I am unprepared, I haven't actually got my redraft done. I did something very similar to Chan. So I went back to my flowcharts that I had for week 1. I've also set up a flowchart for this one, like separating out the structure of a sentence and how
Yep.
that is all to like follow on. And then also I definitely separated out all the sentences. I could not read it in one paragraph like that.
No, and it was designed to be like that, obviously, to make you realize what a bad draft looks like. Having said that, it is based on a real clause. So in some older FPOS transaction arrangements, they did actually look like that. So, it shows you that, hopefully what you will see is that you will have a great degree of improvement just by breaking that up before you even start attempting to redraft provisions and make them more concise. You'll still find that just breaking the material up makes it easier for the reader to digest. Chan was also right in terms of understanding the context and the purpose. The purpose is obviously to facilitate a transaction in relation to the transmission of money from the bank to the merchant, but there has to be certain obligations that are complied with for that to occur. And the context is provided in the memo, I guess, in the sense that it's a poorly drafted clause. The aim is to redraft it, but of course, in reality, you'd see the entire agreement and you'd have to make sure that it fits within the entire agreement still. So one of the things that you wouldn't want to do when you're thinking about context is you wouldn't want to be changing the word merchant to something else, because firstly, it's got a capital that tells us that it's a defined word. But secondly, even if it didn't have a capital, it's probably a defined word, and you would want to go to the definition section and check that, because if you started substituting merchant for something else, there's a risk that then the contract becomes inconsistent. Okay, so with that context in mind, it sits within an existing contract. You also need to think about, well, if I'm amending this one clause and I'm creating a series of clauses, I have to go and renumber the rest of the contract. So, there's consequential aspects of your drafting that have to be taken into account. So I totally appreciate that you guys haven't had the remainder of the contract, but that's something to be alert for when you are redrafting aspects of a contract. In reality, in legal practice, quite often, if you're looking at a where parties are not involved in a litigation dispute, but they're actually trying to formulate a contractual relationship between the parties, quite often one party will draft the contract and then supply it to the other for comment. And in those instances, if you're on the receiving end of the contract, you're going to be redrafting aspects of that contract rather than providing an entire contract from scratch. And so that kind of looking at how it affects the rest of the contract, how it fits within the rest of the contract, is a really important step. Okay, so let's do some brainstorming generally about what to do with this this clause. Okay, so I'm just going to share my screen and I'm just going to get up the whiteboard, the blank whiteboard. Okay, can you guys all see that? Yep, all good? Okay, so what we'll start off with is what do you think one of the first steps might be in this instance? Now, I can't see the chat at this point, I should just point out, because I'm on the whiteboard, so you guys will have to unmute. So when you're looking at the clause, when you're looking at, so we've got the context, we've got the purpose. When we're looking at the clause specifically, what are some of the things that we need to think about when we're redrafting?
The subject.
Okay, what do you mean by that?
So I'd be looking at what is the sentence trying to tell us? Like who or what is that sentence trying to portray or instruct?
Okay, so does it relate to the obligations or rights of one of the parties?
Yes. Yes.
Okay, so that's looking at the sentences individually. Okay, all right, what else?
Definitions.
Okay, great. So that would, I'm going to put that down here.
What is that?
Yeah, so definitions. So what existing definitions are there? And then also, what new ones might you need? Yeah? Okay, good. What else? Well, what about identifying what each sentence is trying to do? So Tammy kind of said that. She said you've got to look at what, focus on what the obligations or rights of the parties are in each clause. But each sentence does a different thing, sometimes two things, but each one does a different thing. So maybe we also, these are in no particular order, we need to look at the content of each clause and identify the principle or the rule within each clause. Yeah? Because then we can start to think about structure. If we can do a dot point for each sentence of what it's trying to cover, okay, then we can then identify what the most logical order is for the presentation of that information. So did anyone think about what the main principles this clause was trying to cover? I know there's lots of sentences in there, but what kind of things were they trying to cover?
Just like things regarding the transactions.
Yep.
And like the information that the merchant needs to send to the bank.
Yep.
So just confirming details like that.
Okay, so it's got transactions.
Yep.
So one of the first things that it does is it talks about how the transaction occurs. What's the process?
Yes.
Right? So let's write process of transaction here. All right, but it also doesn't just talk about the process is, actually putting it into the FPOS machine, isn't it? And then pressing send and the receipt coming out and all of that kind of stuff. But there's more to it than that. There's another aspect to it. What else was it talking about?
It was talking about if the merchant wants to create an account. I don't have the clause in front of me, but it was a deposit account.
Okay.
And
yep.
that.
So
and
that's related to payment, isn't it? There. Okay.
Also,
yeah. No, you're absolutely right. So payment, and there's two different scenarios that are presented there. So the first is where the merchant has an account.
Yep.
With the bank, and then there's a scenario where there is no account with the bank.
Right.
Okay. All right. What else is missing here, though? We've got process of transaction. What other information were they trying to cover? I'm going to number these actually.
Reconciliation.
Yeah. Okay.
Like to actually do that sort of end of the day.
Yeah. I think that I'm going to put that as 3 though. But yeah, so that's when you have to do that present it or initiate the summary transaction, yeah, which then that feeds into the payment process, doesn't it, as well? So the reconciliation, there's something between that though. It's what information must be included in the transaction. Okay, so what must appear on the receipt?
Yep.
Yeah, do you guys all remember that from the
Yep, it's like the cardholder's signature.
yeah, that's right. So hang on a minute. Can you guys still see what I'm writing? I'm just checking.
Yes.
Okay, that's all right, because I've come to the end of my screen. I've got to move everything around so I can still see. Okay, so number 4 is payment here. Whoops. Won't let me write number 4 there now. Okay, so down here we've got also there's something else in relation to payment. Can anyone remember what that is? There's a condition relating to payment. So I'll put this as 5. Payment is number 4.
Yeah. I believe that a payment can only be approved if the goods and services are available. Is that what you're referring to?
Yes, it's not if they're available though. So you're right, but I don't know why I've put 5 there instead of 4. Sorry, my numbering's gone crazy. So it's actually the obligations on the merchant regarding the sale. Okay, so it's that at the end they talk about the fact that payment must not be put through the machine basically unless the goods have been supplied or the services provided. Yeah?
Yeah.
Okay, so you would have noticed that because you did your merchant obligations and bank obligations. But what we're really looking at here, again, sorry for the funny numbering, is 5. We've narrowed it down to 5 separate principles within this clause, okay? So the process of the transaction, what information must be included in that transaction, the requirement that the merchant engage in or initiate the reconciliation process. Fourthly, that the payment, how payment is affected by the bank, and that is conditional upon which scenario applies. And then finally, there's a further additional requirement on the merchant regarding the processing. So actually number 5 probably relates to 1, right? They shouldn't be putting it through, they shouldn't be putting the transaction through unless the goods and services have been provided. So although in this clause that number 5 comes as the last line, you might want to think when you're structuring your redraft whether 5 is attached to 1 and you put those together. Now you don't have to have it all in the one sentence. You could have 2 subclauses there that relate to that scenario. Okay. The next thing to do is once you've got your list, other than that thing that I've just pointed out, is also think about the order in which you're going to present those principles in the draft. Now it might be that we've already got the correct order, but you should always think about whether or not there is a more logical presentation. So here 5 might go better with 1. If the clause had been drafted in a slightly different way and you'd got payment occurring before the process of the transaction itself, then logically you'd switch those round, because the bank doesn't have to think about payment. There's no obligation on the bank to pay until the process of the transaction has been effected. Does that make sense? Everybody following? Thumbs up if you're following. Okay, good. All right, so what we've really done here is we've talked about the purpose, what we're trying to do. We've thought about the context and the fact that it's sat in an existing agreement. And that shines through when we talk about definitions, because we'd have to be consistent with existing definitions and not introduce new terms. And be mindful that when we create brand new definitions, they will apply throughout the entire contract unless they're displaced by the context. And we've also identified the key principles within the relevant paragraph, broken them down, and then thought about the most logical order to present them. Now, at this stage, it then becomes a matter of how it sits within the existing agreement as to whether or not you decide to stick to one clause per principle. So let's just say the numbering starts at 5. So clause 5 would be the process of the transaction. Clause 6 would be what information must be included. Clause 7 would be reconciliation, blah, blah, blah. Or whether or not you think, I'm just going to stick this all in the one clause, but there will be a variety of subclauses. So 5.1, 5.2, 5.3. So that again is dictated by what feels the most logical, and also how it sits within the rest of the agreement. Because of course, if you start renumbering, it's not just the fact that, let's say we insert 5 clauses and that makes the contract 5 clauses longer. It's also the fact that you may have cross-references throughout the contract. So say in clause 37, you might refer to clause 8, but that clause 8 is now clause 13. Okay, so again, we've got to be mindful of those kind of things as well. Okay, so let me stop sharing that and I'll come back to talking to you all. So does anyone have any comments in relation to the sort of preparatory stage that we talked about there? Any comments or questions? You can write them in the chat or unmute. I'm happy for either. I can see the chat now.
Question.
Yeah.
When you talked about cross-referencing, is that something that you'll be covering later on how to do cross-referencing, or?
Yeah. So Selvi, it's not really something that we need to cover in itself, because it's just really just common sense that if you decide to refer back to a particular clause, you do that by reference to the clause number. Okay, so you would say, so for example, let me give you an example. You create a general principle and then you have an exception. You might write in the general principle, subject to clause 8, which is the clause that follows. Does that make sense? So in clause 7, you'd have your general principle, but it would start with subject to clause 8. Does that make sense? Mm. Yeah, so that's really the extent of what you need to know about that. Of course, whenever you renumber, that means that then you have to go back to all those subject to or except as provided in clause blah and renumber all of those as well. But it's okay. Just not every clause will relate to another clause, but if you're building an area, so an area of the contract over several clauses, then they might relate to each other. So if your payment, let's say payment is dealt with in part 2 of the contract, and part 2 is clause 10 to 15. Okay, so that you've got five full clauses that deal with payment. Then in that situation, your clause 15 might refer to clause 12, or clause 14 might provide a defense to the requirement of payment immediately, or whatever it might happen to be.
Okay.
Okay. That's okay. I mean, again, when we get to contracts, you'll probably feel a bit more confident about that kind of stuff, because we would have done some initial drafting. And also, when you have to play with an entire contract, you start to then see how it's a bit of a jigsaw puzzle, and you might need to refer to payment when you talk about supply of the goods. Do you see what I'm saying?
Nicola, just
yeah.
a quick question.
Yeah.
Like in the real world, like if you were a solicitor, how long would you have to draft a document? Like what's usually the?
Oh, it varies. So it depends on lots of things, like how quickly your client needs it, how quickly you need to get a response to the other side, whether your supervisor's left it till the last minute and thrown it at you instead, which happens, of course, and also how extensive it is. So if it's a standard form contracting, you're just tinkering with the parameters to make it work for the parties, you're going to be able to do that much more quickly than something that you're drafting from scratch, or an area that's incredibly complicated and requires a lot of review before you can actually go in and draft the relevant provisions. So it really depends on whether you're working with a precedent, the area of law, and all of those kind of things. So it's really an indefinite answer, really. But, you know, this kind of scenario that I've set you, you know, you'd expect a trainee to knock that out in the afternoon, really, because it's just one clause. The entire contract, with a trainee, you might expect them to take half a day to a day to do it, but as a lawyer who's skilled in billing the client by the hour, you know, you'd probably bill a couple of hours on that as a maximum.
Yeah. Thanks for that.
That's okay. But, you know, with experience, you get quicker. And that's one of the reasons people pay more for an experienced lawyer, because technically, you know, a trainee doing the work is a false economy because they're much slower, or a newly qualified is much slower than an experienced lawyer who does this stuff day in, day out. So, okay, so I'm going to share the screen now of the actual clause, and again, we'll talk through the clause itself. So let me just find it. Where did that go? Is that it? Nope. Hang on a sec, just give me a second. It's because it's not on my screen yet. There we go. Share screen. Yeah, okay. So hopefully you guys can now see the clause. So sentence by sentence was obviously a good idea to start off with. Can anyone tell me their thoughts when they read the first sentence, which I've just highlighted there?
Too many conditions on one sentence.
Yeah, okay, good. So there's a problem there with also this as provided in section 5 hereof. Clearly that means that this is section 5, but do we actually need that here? Probably not. Okay, and hereof. Anyone know what's wrong with hereof?
What does it actually mean in this context?
Yeah, it just means here. It's just really old language. Okay.
That's right, yeah.
It's like where people write herewith and forthwith and all of those kind of things. It's just words. It doesn't mean anything more than what you've already written most of the time. And certainly you could choose a better version. You know, please find attached is enough. You don't have to say,
oh, ye Shakespeare.
Herewith. Yeah. Yeah. And I mean, you know, when I first started out in practice, I wanted to use that because I wanted to feel like I was a proper lawyer, you know, kind of fake it till you make it kind of thing. But the reality is that that's not how we communicate, because it locks out a large number of people. Okay, so yeah, so that last part of the sentence is problematic. There's no doubt about that. Also, there's a problem with the word shall. Now, this is something that we cover next week, okay? So just make a note to come back and look at this next week. But shall has multiple meanings. It has lots of different meanings. It can be conditional, it can be future, it can mean may, which is discretionary. So in this instance, which, I mean, as a general rule, I want you to try and avoid using shall wherever possible, okay? In this instance, we can replace it. When we look at this sentence, is it that the merchant has a discretion, or is it that if they decide to submit a transaction, they must do it as set out in the following clause?
They must do it?
Yeah, absolutely. So the first thing that we can do is look at that and say, well, shall can be replaced with must. Okay. So the other thing is as well that I'm not sure that we even need if the merchant has electronic processing capabilities, because, well, they wouldn't be submitting something for a transaction if they didn't have the electronic processing capabilities. So I wonder why that's there. Does that make sense? In the context, this is all about submitting something through an FPOS machine. I'm not sure why you need to say if they've got those capabilities. If it's working, they'll use it. And if it's not working, they won't be able to use it. So that was just something that I thought was probably unnecessary.
Won't you think that if they do have those capabilities, then the clause is saying if you do have those capabilities, you have to use it. You can't submit it in any other way.
Well, but the question is
Would that be
yeah, I mean,
another way to...
it's relevant. I guess, maybe that part of the sentence is trying to refer to if we have a power cut, we won't be able to use them. Or, so systems are down. Or maybe it's saying that if they want to do an FPOS transaction, they must exclusively use that FPOS machine. They couldn't have two different machines from two different banks. But the point I'm trying to make is that that's not clear, that that's what they were intending to achieve with that statement. So if you want to make it that they have to use those means, then you should make that clearer. Does that make sense? Yeah.
Yeah.
Okay, good. All right, so that's fine for that sentence. What's wrong with the second sentence here? So the bank shall authorize or decline such transactions transmitted for authorization and shall capture and process for the merchant the information relating to the transaction. So there's two different obligations here that it's talking about, isn't it? It's firstly that the bank has to decide whether to authorize or decline, but secondly, if it presumably, regardless of whether it authorizes or declines, but that again isn't clear, but presumably it should then capture and process relevant information. Okay. The reason why I say presumably is because I don't know whether you guys have ever had your card declined at an FPOS terminal. I have. And it still spits out a receipt saying declined and the reason why. So I'm assuming here, but I'm making an assumption, and I should check with my client, that the information needs to be captured in both instances, okay, whether the card is declined or authorized. But we should double check that. Sorry, Selvi, were you going to say something?
No, I'm fine.
Okay.
I was going to quickly say something.
Yeah, sure, go ahead.
With that sentence, Nicola, I actually I approached it in a way where it's like a possibility, like as in the bank can authorize or decline such transactions transmitted and so and so. And I actually broke up the sentence into two sentences. So I can't remember what I wrote, but yeah, that's what I did, just to break it up and just to communicate that.
Yeah, no, you could totally do that. So you could start off with a header and have it as two subsections. So you could start off with, for example, once the card is presented to the terminal or whatever, once it's been presented, the bank must, one, authorize or decline such transactions.
Oh, it's a must. Okay.
Yeah. Well, it's got to do one or the other.
Yeah.
You can't leave people not knowing whether their card's been accepted or declined, right? That's my thought. So the bank must authorize or the bank must ... authorize or decline such transactions, and two,
and can capture.
Capture, because if your header is must, you have to then have the verb, right?
Correct.
So must capture and process the information relating to the transaction.
Okay, I think the word shall confused me.
Yeah, well, that's because quite often it means may. When we use shall, when we talk, quite often we mean, when I say I shall go to the cinema tomorrow, I'm really saying I'm probably going to go, right?
Yeah.
So quite often it means may, and it also means conditional future. So that's the problem with shall. It can be confusing. But really, when you come back to this, you have to think about whether or not the bank has a discretion or whether it's compulsory. If it's required, then it's must. If it's a discretion, it's may. So you can have, the reason why I put must in the header was because you have to have an authorization or a decline, but you can have further information about discretion within that. So you could say, once the blah blah is presented for the transaction, the bank must authorize or decline such transactions in its discretion, which then reflects the fact that it can decide whether or not to authorize or decline. Does that make sense?
Yes.
So you have the discretion with the authorizing or decline, but at the same time it's saying that they must do one of the two.
Yep.
So in writing these sort of clauses, you mentioned when the card is processed, those words, do they have to be repeated every, this is one of the things that I was actually contemplating when I was writing the clause, rewriting the clause. At what stage do I actually repeat? For instance, this only takes place when this happens. For instance, the bank must authorize or decline such transactions. That refers to the card. So
Yeah,
do
so
I repeat?
for example, let me just give you, I think you're asking this, which is, so let's just say that the bank chooses to authorize the payment, then it would invoke the payment clauses that come later about how that payment occurs. So you could, instead of repeating where the bank has authorized payment, blah, 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 in the following circumstances, you can just say where payment is authorized in accordance with clause above. Does that make sense?
Yeah, okay.
Yes.
Yeah,
Yeah.
that's good. Yes.
And that won't necessarily cut the words down, though. It depends on how much you were going to say in that space. But it's still it's logical to do that, because you're saying when clause 2 is when clause 2 is met, then this clause operates. So there's a logic to doing that.
Yeah, but do clauses get written in such ways, like when you say, okay, when such a thing happens, then only this happens, or do you make that assumption that like transactions refers to merchant card transactions?
Yeah, no, they do get written like that, because then it makes it clear at what point the obligation kicks in. Now,
Yeah.
you and I and everyone knows how contracts work, and so you could imply all that in, and sometimes the courts will imply those kinds of things into a contract if they're missing. In contract law, you will have learnt about implied terms. So it might be read into the contract, but when you're trying to draft with certainty and precision, it's a really good idea to try and cater for that at the outset, rather than requiring the courts to read in to the
Yes,
contract.
to make that implication.
Yeah, because there's a
rather than
risk that they might not interpret it in the way you intend. So
yes,
best to be overt. Does that
yes,
make sense?
rather than using the word such transactions,
Yeah.
you do specify what you're talking about there.
Yeah. Yeah. So, but yeah, I take your point about duplication, and it's a fine balance, but you'll get once you've done your initial draft, which I saw that you'd done on the forum, once you've done your initial draft, you can then go back through and see whether or not you can relate any of those clauses to each other, whether you can be a bit more concise, because, if you're talking about subsections, then your header does all the work for all of the subsections, so that's probably okay. Do you see what I'm saying?
Yes,
So
yes, and that's one of the issues that I had. How do I make the header, common to reference to what such transactions actually mean? That
yeah,
is,
yeah,
and so on.
yeah, and headers usually come later, so it's a good idea to get the substance down first, and then think about what header reflects the substance. So yeah, don't worry about that for now. Okay, so let's talk about the third sentence. So here, I don't like this sentence because it's got commas in it. Okay, so anyone identify problems with this clause? This sentence.
Plenty of problems. Too many convoluted conditions there.
Yep.
Shall not be limited to.
Oh
Yep.
gosh.
What does it mean?
That's quite a common phrase that we see in legal drafting. So it's trying to make it clear that it includes the following, but not only the following. You know, so this is just an example list is what it's really saying, but it's a long-winded way of saying it. What else is wrong with it? Anyone?
The word accepting.
Yeah, I don't like that either.
Yeah.
That a better choice of word could be written there. Absolutely. What else?
The word shall is there again.
Yeah. Yeah, another bugbear of mine. Yep. Well, the first part of the sentence is written in the passive voice. So the information to be transmitted by the merchant.
So
Okay.
active.
Yeah, so the information to be transmitted by the merchant through the terminal shall include. So that can be written just as the merchant must transmit the following information. Yeah, because then you put the merchant, which is the one doing the transmitting, at the beginning of the sentence, makes it active. It's the problem with the passive voice is that when you put it in a long sentence, it becomes really difficult to track what's happening and who's doing what. So always aim for active wherever possible. Okay. So the other thing that I thought was with these random clauses that are created, so every time you use a comma, you create a clause. The problem with these commas is that it's not clear to me, and tell me if you agree, whether or not what is accepted, i.e. excluded from the information, is just the description of the goods and services, or whether the signature and the description of the goods and services are excluded. Can you see that? So here, it's saying the information shall be all of that information required on a sales receipt. Okay, so the starting point is, our general rule is, you've got to include in the FPOS information all of the information that you'd put on a sales receipt, which would presumably be the amount, whether it includes GST, how much GST is, all of that kind of stuff. Yeah. Then it says except. So it's saying this information does not need to be on in the terminal. Okay, you don't have to provide this information. And then it goes on to say accepting only the description of the goods and services provided and the cardholder signature. So my question is, does that mean that you don't need the signature and you don't need the description of the goods and services? Or is it actually saying you need all the information on the sales receipt and the cardholder's signature? You see the clause separates the cardholder's signature there? Yeah. So the comma separates it from everything. So it's not clear whether it's saying you actually need all the information on the sales receipt and the cardholder's signature, but not the description of the goods and services. Or the alternative is all the information on the sales receipt is required, but we don't need the signature and we don't need the description of the goods and services. Now, those are two completely different scenarios. I'm just going to come back to look at you so we can talk about this a little bit more. Hang on. So all of those commas create complexity in the sentence, and they create new clauses and subclauses within that sentence. And so by splicing it there with that comma, it's now not clear, and we'll talk about that kind of situation next week in the Canadian comma case, right? But it's now not clear whether the cardholder's signature is required or not required. So that's something, we can't answer that question because we don't know how this works, but you check with your client what's supposed to be happening here, and then we can draft accordingly, according to the scenario that it falls within. Okay, so does everyone follow that?
Yeah.
The problem is the comma coming before and the cardholder's signature. It's not clear whether it's actually connecting it back to the information that's required or the information that is excluded. Okay, good. Thanks for the thumbs up there, Chan. Okay, so let's go back to sentence 4. Hang on. I'll just go back and share this with you. So sentence 4, here we go. So the merchant will include any additional information necessary for the bank to comply with all the legal requirements for billing cardholders, or as may from time to time be required by the bank and or the approved card issuer. Well, first thing is there, the issuer doesn't have a capital letter. Now that's probably a typo, but if approved card appears to be in capitals, which means it's probably defined somewhere. So to use a non-capital for issuer, if it's a capital used elsewhere, is then a problem, because it's not clear whether you're introducing a new concept there. Okay, so it's even silly things like not using a capital in the right place may cause people to look around and think whether or not you've tried to introduce something new there. Now, as a matter of sensibility, common sense, the court's going to look at that and say it means approved card issuer as defined with capital letters, but you just don't want to create that kind of problem for the parties to argue over, so it's best to be careful with your proofreading. Okay, so comments about this sentence?
From time to time.
Okay.
What does that mean?
Yeah, I mean, that's sometimes included to represent the idea that we don't know if it's going to change and when it's going to change. But you could just put as may be necessary or as may be required by the bank or approved card issuer. You probably don't need that phrase there, because as may be indicates that it's not a requirement, that's not an absolute requirement. What about the word will?
Instead, can we use must instead?
Yeah. So again, why are we going into that future tense? Okay, will. I will do this means you're going to do it at some point in the future. Why use will when you could just use... The thing is, it comes down to one of two things. Either the merchant has to do it, or they can decide whether or not they want to do it. So really you just need to decide between must and may. And most of this is written in the present tense, so we don't really want to then be introducing future tense. So the merchant must include any additional information that is necessary for the bank to comply with legal requirements, blah, blah, blah. Okay. Again, it's written in the passive voice too. Or as may from time to time be required by the bank and or the approved card issuer. Really you can say as the bank or approved card issuer may require. Yeah. Okay, so again, can be tidied up a little bit.
I mean, when I read some of the clauses in law itself, a lot of them in the past have been written with, not in the active voice, but rather in the passive voice. Do you agree?
Yeah, absolutely. Look, some of the precedents that float around are 30, 40 years old. And by that, I don't mean every single clause within that is 30 or 40 years old. What happens is if a new court case comes out that defines or interprets something or takes a particular interpretation of a principle of law, then the precedents are amended to reflect that. So the entire thing isn't necessarily 40 years old, but maybe some of the bones of it are. And so you tend to get some of those historic phrases within the precedents. On top of that, people are frightened to move away from those historic phrases where they're known to be defined in a particular way. So the court looks at the word bequeath, for example, and it has a particular meaning under the case law. So people would rather use that than the word give or whatever it happens to be. That's the plain English equivalent, okay? So people are frightened to move away from what has for a long period of time been determined to be an acceptable phrase to use to draft in that particular context. I'm not saying that as a trainee or a newly qualified you'd want to move away from a precedent in that scenario, but when you start to become a more experienced practitioner, there's always that opportunity to review precedents and decide whether or not they need not an overhaul, but they need, you know, someone to come in and re-edit them so that they're a bit more contemporary.
So if you're re-editing a certain section of a contract, and pretty much predominantly if the contract is written in a passive voice, you would follow that format, wouldn't you? Wouldn't be changing it into active all of a sudden.
Well, it depends on what you're doing. So if your client has asked you to do something and you've only got a limited amount of time to do it, then you're going to work with what you've got, okay, on a practical level. If you're working on the firm's precedents more generally, then you might reconsider redrafting certain parts of it so that it's expressed more in a more user-friendly manner. So it really depends on the task that you've been set. Okay. So
Nicola, just before the previous sentence, I also thought that any additional information necessary to comply with all legal requirements was very open-ended. It sort of left it very, very open. I mean, that would be something that I thought I would maybe refer back to my client and just make sure that there was something that we might have been able to refine that a little bit more.
Yeah, Tammy, that's a really good point. So, I mean, the problem here is that the merchant doesn't know what's required unless the bank tells them as well, right? So really what you'd be looking for is whether or not you can put in a clause that says that the bank will notify the merchant as to what is required for the bank to comply with its obligations. So that, and that notice will be provided, and then the requirement for the merchant to provide that information then kicks in. So you've got that obligation being conditional on the notice being provided. And then it can be open-ended because the merchant isn't obliged to do anything until they've received the relevant notice. Does that make sense? Yeah. Okay, good. So looking at the next one, this is going on to reconciliation now. So the merchant is required to initiate and reconcile one or more summary transactions for each merchant terminal each day. Thoughts on that one?
I changed that sentence around a little bit. I said on a daily basis, the merchant is required to reconcile. I removed the word initiate.
Yep.
Just to make the sentence shorter. So to reconcile one or more, at least one summary transaction.
Yep.
For each terminal.
Yeah, that's a good point. So they're both verbs there, aren't they? Initiate and reconcile are both actions that the merchant is doing. One precedes the other, so the reconciliation can't occur without the initiation, but whether you need to actually have both there is probably not necessary. I think the reason they've put that there is because if you initiate it and it fails, you have to keep doing it until the reconciliation occurs. But then why not just make the obligation reconcile?
Yeah, that's what I was going to say. Yeah. Why, he has put a separate meaning, the initiate, because the reconcile will not always reconcile. So I was going to say that, but you touched on that.
Yeah.
So could we retain it?
Could we what, sorry?
Retain the word initiate there.
Yeah, so, I mean, you just need to select what you think fits and why, though. Why are you selecting that particular phrase over the other, and that's fine. The one thing that was interesting for me was that they'd moved to the present tense. So before it was will and shall and all of that kind of stuff, and now we've got the merchant is required. So, yeah. And also, is it an obligation? If it's an obligation, just write must. So the merchant must initiate, or the merchant must reconcile. And I didn't like the fact that it went for each merchant terminal each day. I just thought that was clumsy. There's nothing wrong with that, but Chan went for on a daily basis. I think you could probably move the sentence around and still use each. So you could start with each day the merchant must blah 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 for each merchant terminal. The reason why they've got each merchant terminal is because some shops are large and have more than one, right? So they're trying to cover a situation where you've got to go from each EFTPOS machine and reconcile them. The other points that I would have raised with my client there are that, are we talking about business days here? Or because the bank's only open Monday to Friday? Or are we talking about every day? And that's important because if you're making it a requirement, the merchant must reconcile. What happens if the merchant's not open on Sunday? Do you see what I'm saying? So you need to work out whether you're looking at business days or you're looking at every day of the week, or whether you can conditionally have it so that the merchant's only required to reconcile on the days that the merchant terminal has been used. Okay. The other thing is, when we say each day, not just are we talking about business days, but when does the day end? Is it when the bank's cut off, which is, I think, 4 o'clock usually Sydney time, or is it 11:59:59? Yeah. So we need to also think about what we mean when we say the word day. Now, of course, if it's beyond the bank cutoff time, the bank's not going to process it. So if we say it's okay to reconcile at 11:50 p.m., okay, or 11:59:59 p.m., that's not going to be within the bank's processing time. So that actually spurs an additional clause there that the bank is not obligated to process within that day if it's beyond the bank's opening hours. You know, you need to think about consequences when you're drafting like that. And those are matters for your client to work through with your client to work out what they're looking for in that draft there.
Nicola,
Yep.
in that instance, like, would you define day or each day or day in the definition section, or
Yeah,
would you just go ahead and like write?
Yeah, no, that's
Okay.
probably a good idea, unless when you look at the contract as a whole, you then think that day needs another meaning, in which case you'd put in your time, or you'd have it in the clause itself. For the purposes of this clause, day means blur, or time means blur, or whatever phrase you select. Does that make sense?
Yes.
Okay.
In the absence of the actual contract, though, I mean, that would again be just potentially writing a new definition, because there could already be a definition of day or time or any of those further up in the contract.
Yeah, absolutely. So it really just depends on what's gone before. Sometimes you'd get your understanding of the word day from the other clauses. Yeah, so, you know, again, it's about understanding the whole thing, the whole context. All right, sentence 6. Okay, so what did we think about sentence 6? I've got quite a lot of notes for that.
It was fun breaking up that sentence.
Yeah.
I moved the subject to final payment of such transactions to the end, just so I can like organize the sentence.
Yep.
But I noticed that, you know, there's like the word cutoff time, so that's pretty important. And
Yeah.
yeah, I broke up the sentences. That's what I remember.
Now, the cutoff time is established by the bank, so it's not a defined term in the contract. It's actually provided by the bank. So the bank says this is our time when we close our business for the day. In that instance, I mean, that's in the passive voice again, but you would want to have a clause that also indicates notification of that cutoff time. Okay, but you probably also want the ability for the bank to be able to vary that cutoff time with notice. So you would want some aspect of your drafting to reflect that. At this point, we switch from reconciliation and processing the transaction to payment. So you would definitely want either a new probably a new clause here, but if not, certainly a new subsection, new subclause in for payment on its own. And in this instance, what it's really covering is how it's going to process the transaction. So there's a provisional crediting of the deposit account, but that's not the final reconciliation. So it's explaining that this sentence is explaining that there is a provisional reconciliation, but it only occurs if it that provisional reconciliation at the bank's end only occurs if it occurs before the bank's cut off. Okay, so that can be tidied up quite a lot. And then it goes on to that split that we talked about between where the merchant has an account with the bank and when it doesn't. And it does that. I'm just going to come back and talk at you for a minute so we're not just staring at the screen the whole time. So it does that really because it's a commercial sort of practicality, that if the merchant has a transaction with the bank, a transaction account with the bank, it's really just about them entering the figures, obviously electronically, but entering the figures into the new account and the money is credited. But where there's no account with the bank, it's more complex. They have to go through a third party to credit the money because they've got to go through the bank that holds the merchant's account. Does that make sense? So at that point, the bank loses control because it sends the transaction to the other bank and then the other bank processes that transaction. So it becomes more complex, the transaction itself, but the time frame becomes longer. So it makes perfect sense that they need to distinguish between where the merchant has an account with the bank, because that's a really simple accounting process within the bank, and where the merchant does not have an account with the bank, and that needs to have some leeway in it because the bank loses control of the final step in that process. So of course it makes sense that they divide it, but they don't do it very well, and that's really where you guys come in and need to think about how you're going to structure this. You need to separate them out and then think about the requirements under each. So let's go very quickly back to that draft. I think we're going to run over a bit today. Feel free to leave if you've got another thing to go to. So comments that you want to make about this particular clause?
The definition of what a final payment is,
Yeah.
unless it's already defined.
Yep.
And what does subject to final payment actually mean?
Yeah.
Of such some transactions, what does that actually mean? It has to be defined very clearly.
Yep.
Before it can be even used as a condition.
Yep.
Yeah.
Now, actually, Selvi, in your draft, I noted that you'd really broken that up quite into one line for each aspect. So you'd looked at the amount that is deposited is equal to the amount reconciled. Then you've got the deposit must occur prior to the bank's cutoff time. And then you'd got a separate section for what the final payment was as well. So I think in this instance, if you're going to say subject to final payment, what they mean by that is payment coming from the card issuer. If you're going to say subject to final payment, why put it in brackets like that in the middle of the sentence? If everything is subject to receiving payment and all of this is just a preliminary reconciliation, if it's going to be subject to that final adjustment process, why not put that in the header for the whole thing? Okay, so subject to the final payment of such transactions, or subject to reconciliation with the card issuer, or however you want to phrase it. But put that at the outset to make it clear that it's all conditional upon what really comes through. So subject to that situation, the bank must credit the deposit operating account in an amount equal to the reconciled summary transaction, and then provided that the transaction total is received prior to the bank's cutoff date, or something similar to that. Okay, so next sentence. Credits to the merchant's deposit operating account will be available on the business day following receipt of the reconciled summary transaction unless the bank has notified the merchant of an alternative availability schedule. So here this is still relating to the merchant having an account with the bank. Now, that's only there by implication that the merchant has an account with the bank. So I would personally put this sentence and the previous sentence together under one clause and have the alternative scenario of the merchant not having an account with the bank completely separate. So here, just make it more overt, really, is what I'm trying to say. But here, what they're trying to say is that if you process it before the bank's cutoff time, then the money will be available the next business day. Okay? Unless the bank has notified the merchant of an alternative. So it's possible that the bank could say, actually, we're going to work on a 3 business day transaction process. Now that's fine, except for the fact that how is the bank notifying us? When you look at that, does it tell us how the notification takes place?
Written, it says, but...
It doesn't. It should say written.
Maybe I read it somewhere else as written.
Yeah. I think you put written in yours, and that's the right thing to do, because in a commercial transaction, you really want to have written, so you've got tracking of everything that's happened between the parties. Yeah. Now, that written notice doesn't have to be by way of letter, okay? You can have a separate clause in the contract that says that all notices are deemed to be received when they're sent via email or something like that. Okay.
It does say written notice on the next sentence. It says written notice.
Yeah, well, what that tells us actually is that if you were reading that, you'd say, well, then notified must mean something else. Because you're switching between 2 different phrases there. Notified may or must mean something else. The only reason why you can connect them together is because actually the next sentence is part of the explanation as to what's happening in the sentence that we're looking at now.
Yeah.
Right.
Yeah.
So you want to tidy all that up and get rid of all that ambiguity. So next point is actually that, which is, let me highlight them both, which is when we get to this sentence here, the bank reserves the right to change. Well, that's kind of really saying the same as the previous sentence, which is that the bank can change its mind about the availability schedule if it wants to, and must notify the parties that it's done that. So those 2 sentences can be put into one clause and just rewritten so that they express that content more clearly. They're on the same topic. There's an element of repetition between them. Put them together and just make it work better. Next thing to look at is the alternative scenario. So separate clause. If the merchant doesn't have an operating account at the bank, it will be credited in such manner as the bank shall deem appropriate. Now, shall and deem...
Sorry, can I just interrupt you for a minute there?
Sure.
In the previous sentence, it says, any such change effective upon written notice. That's very difficult to comply with, because the written notice because it's on by written notice, the notice may not be available. It could come by snail mail, it could be email, which you haven't noticed. So that's a very ambiguous
so what I said was that you probably want to have a clause separately at the back of the contract, usually there, saying how notice will be provided. So notice will be provided in writing and will be deemed to be received by the other party when sent via email. So a bit like the postal rule, right? So, but in this instance, we're getting rid of that and saying that the notice is deemed to be received when it's sent, or alternatively when it's received, when the email is received. But when we say it becomes, and that's another point, when it becomes effective upon the written notice being received, is it effective immediately, or is it the beginning of the next day, or the next business day? Or would it make more sense for it to actually be on the first day of the following calendar month? You know, so you need to think logically, and you need to get instructions, but you need to think logically about when we say effective immediately, we quite often don't mean the millisecond after it's been received, and think about what that actually means in terms of how the contract's going to operate.
Yeah.
Okay.
So in such cases for this exercise, when something like that comes up in an assessment, do we rewrite those clauses? You know, would we be expected to rewrite those clauses upon what we think is right?
Yeah, I mean, you're not going to have an assessment that looks like this.
Okay, all right,
Okay.
that's good.
Yeah, so I'll just come back to you again because I don't want you just staring at the screen for a couple of hours. So the week 4 assessment will require you to redraft a couple of things, but they won't be as long as this. It'll be like 1 sentence or maybe 2 sentences. So,
Okay.
you know, it's a really small exercise that you can do within a couple of minutes, hopefully, just applying what you've learned. So it's not going to look like that. Don't panic. Okay. And a lot of it is going to be multiple choice rather than redrafting, but there'll just be a couple of small redrafting exercises. But, you know, I would take 1 or 2 sentences from that entire paragraph and say, work with this. Okay.
Yeah.
And really it's more about what I'm really testing you on is if you can identify the problem. It's actually not about the redraft, it's about avoiding the problem, if that makes sense. So avoiding shall, you know, and that kind of stuff. Okay, let's just go back because we're nearly at the end now. So if the merchant has established has not established a deposit operating account at the bank, the merchant will be credited in such manner as the bank shall deem appropriate. And I don't know why we've got double bank there. That's probably a typo, unless something else is meant. And again, use of shall and deem, don't like those. Definitely don't like shall, but deem as well. What does deem really mean?
I changed the word to consider.
Yeah. Yeah, I mean, you could definitely do consider, which is a bit more of a contemporary or modern way of saying deem. But really what we're saying is in the bank's discretion, aren't we? It's in the bank's discretion. But also, I think here, there's probably not enough certainty for the parties anyway, and I'd want to get more instructions on this. You know, I'd want to think about whether or not we can mirror a little bit of the earlier clause with the operating account that the merchant does have at the bank. You know, can the bank set out what it wants and how it will operate? So can the bank say it will be credited in the following circumstances? So where you don't have an account with us, it will be credited to your bank within 3 business days. And then you can have a clause that says, but the bank is not responsible for other banks processing that payment. You know, you can deal with it in a much more certain fashion than just the bank will do whatever it likes, which is really what it's trying to say here.
Yeah.
Yeah. Okay. And then what else? So you could have something like going back to the previous clause, I was thinking that you could have something like the bank may at any time vary the availability schedule by providing notice in writing to the merchant. The notice provided in clause blur, which you've just done, is effective on the first calendar day of the month immediately following receipt of the written notice, or you could put on the first business day following delivery or receipt of the written notice, whatever. You could do something similar here with the non-bank account. So you could say, you know, it will be processed within a certain time frame. Any changes to those processing times will be notified in writing. And then you've covered the situation of the bank can extend that time frame in the future if it wants to, and make it 5 business days rather than 3. And you can also cater for the fact that the bank's not in control at the final end with the other bank, and you've covered everything but provided more certainty at the same time. Okay, final sentence, and then we'll just have questions and you guys can escape. So in this scenario, now this related to one of the earlier clauses as we talked about, because it's all really related to processing the transaction rather than the payment of it. But here we see that we have switched from the obligations on the bank. Previously, the previous sentences we were talking about the bank processing the payment. Now we switch back to the merchant. The merchant is obliged not to process a transaction unless the following conditions have been met. What do we think is wrong with this clause?
I don't like the structure of it, how it's just running on as a sentence as opposed to like just having its own paragraph.
Yep. Okay, so I mean, I think they've tried to create a list here that's easy for the reader to follow. You know, you've got one,
okay.
little one, and then the word or, which shows that they're alternatives, and then little two. But that could have been done if you'd got clauses. You could have, you know, 6.1, 6.2,
Yeah.
which would, and then what you're doing is you've not, as you say, it's all just bunched up into one long sentence. If you make it 6.1 and 6.2, you then get a list. It's much easier at a snapshot to see that it's a list, and it's much easier to identify it's an alternative because you'll see all there and know that 1 and 2 are alternatives. So I think that you can still take that information just as it is and make it read better just by changing the layout.
Yeah.
Shall is obviously
Shall's
problematic.
there, yeah, I was just about to say that. And is this an example of a passive sentence, or is it's got the word merchant there, but it doesn't say the merchant? So I don't know if that makes a difference.
I mean, throughout the whole thing, it's just there's no the there.
So would that be considered passive?
Yeah, not really. I mean, it is passive when it comes to the goods have been supplied or shipped. It doesn't say who's supplied or shipped them. So that makes it passive.
Okay.
But the implication has to be that it's the merchant because the merchant is taking payment from the customer. But yeah, again, implications when you could be clear is, you know, clarity is preferred. It's an interesting clause because here it's talking about the merchant's contractual relationship with another party, not the bank, right? Because it's saying you can't process the customer's payment unless you have supplied the goods to the customer. That's nothing to do with the bank, right? The bank just facilitates the payment process through the FPOS machine. So it's interesting that the bank is trying here to interfere with and control and have influence over the contract between the merchant and the customer. The reason why it's extending its reach beyond its own contractual relationship with the merchant, I think, is probably because in certain instances there are certain guarantees that come with the use of things like credit cards. So you can have a situation where sometimes if you pay for something on a card and then it's not received, you never get it, you can actually claim your payment back from your card issuer sometimes. Okay, so you then have a situation where, you know, the bank and the card issuer may have facilitated the credit to the merchant, but the merchant never supplies the goods. Does that make sense?
Yep.
So the merchants receive the payment, but the goods have never been delivered, and then the consumer looks to the bank and card issuer for a refund. So in that instance, who loses out? Well, it's the bank and the card issuer, isn't it? Because they have to credit the customer back, and the merchant has still got hold of the goods. So I think that's what that's there for. It's trying to accommodate all of those guarantees that come under the consumer law and all of that kind of stuff. But I And what it's doing is it's basically saying, merchant, you are in breach of contract with us and we can sue you, or there'll be certain consequences later on in the contract, I'm sure. There will be consequences if you take payment for things that you haven't sent out or shipped out or provided services for. So they've tried to mitigate some of their loss that they will sustain in that scenario that I just described. But it's interesting because it doesn't jump out at you that it's actually looking at a third-party relationship, okay, a third-party contractual relationship, but that's what it actually is doing. So I thought I would share that it's something to look out for, and you've got to think about the bigger picture of how this transaction is processed, but also what other parties are involved at some intervening step along the way. So you've got your consumer, you've got your merchant, then you've got your card issuer, and then you've got the bank. And you need to have an understanding of that entire process in order to make sure that your drafting aligns with what's required there. Okay, so we've identified most of the problems, if not all of them, in that clause. And we've talked briefly about some of the different ways that we can counteract those problems. If you guys, now that you're a little bit more confident because we've been through that material, if you guys want to post your redraft attempts on the forums or in Microsoft Teams, please do so, because I can have a look at them over the next couple of days and give you some feedback. Or if you want to take a couple of days to redraft them and then post them, I can certainly look at them between now and our next workshop, no problem.
Oh, yeah. And that'd be really great.
Well, I've already given you a bit of feedback on yours, Selvi, which I thought was pretty good. You definitely, now that we've discussed some of those issues with the words that they've selected, I think you can go on and improve that draft. So one of the things Selvi said, for the benefit of everyone else, is that she didn't know whether she could change things like will and shall, whether her redrafting should just move the words around rather than replace them. And my answer is this: if it's a defined word, you definitely don't want to be replacing it, okay? Because it's there for a reason. You don't suddenly want to start calling the merchant the seller, okay? Because then the court's going to look at that and go, is this a new person or is it the merchant? And if it's a word that's used frequently in the contract, then yes, you need to think about it. So if the word day appears here and it's appeared throughout the contract, you might get an understanding of what the word day means. It might mean the next business day, or it might mean the next calendar day. Okay, so again, with that context, if it's a frequently appearing word, it might have an implied definition. But apart from that, yes, if it's just words within the sentence that help make up the sentence, like the verbs, then definitely replace them. If you think initiate doesn't work and reconcile is better, use reconcile. If you think will is poor when it could be may or must, replace it. So the basic components of the sentence can be changed. Like Chan was saying, I didn't like each day, so I replaced it with daily basis. You can replace all of those with suitable alternatives if you think so.
Was I going too far? Or
I'm not sure daily basis is any better than each day. But if if the sentence works better for you, then go with it. And there's an element of drafting style too. You've got to allow yourself to communicate in the way that you think works. The other thing is as well that in terms of, it's not just replacing words that are old and antiquated, and like removing hereof and herewith and all of that kind of stuff and replacing shall with must or whatever. It's also about restructuring the sentence if you can make it clearer. So when I said earlier you got a comma there, and that means it's not clear whether the cardholder's signature is an exception or a requirement, you need to restructure that sentence so that that becomes clear. It might be that you, rather than restructuring the sentence, you create two subclauses, and that's fine. But you need to think about how you restructure the sentence for clarity, as well as replacing words in the redrafting process. Okay, so that's pretty much it from me. Does anyone have any questions?
Yeah. Quick question.
Sure.
On my draft, I wrote you tended to use the merchant, the bank instead of merchant, like it was in the clause. Now, does that actually mean a different thing, like the merchant from merchant?
No, I mean, the presence of the being there or not probably doesn't mean anything different, but you really want to think about whether or not the sentence would just flow better if it had the there or didn't,
Yeah.
if that makes sense. And also bear in mind that if you did start to introduce the merchant when the rest of the contract doesn't have the, you're then just adding to the interpretive issues.
And big.
I add the word there as well.
Yeah. I mean, I prefer it, even though it doesn't make any difference, okay? I prefer it just because I'm a bit of a grammar fanatic. But, and I don't like it when it doesn't have the in front of it. But that would mean that I'd have to go and change the whole contract.
Oh, okay.
Yeah. Yeah. Any other questions?
Nope.
No, I think I'm right.
Okay, good.
So sweet.
Okay, well, as I say, have a go at the draft and then post it if you want some feedback. There's also a very, very short, I think it's 3 questions, sort of quiz on what we've covered this week and last week. So just have a go at that to get you used to doing the multiple choice questions, and ready for the test obviously coming up. But yeah, that's it. So next week we're looking at more grammar. Please don't groan. We're nearly there. But next week's a bit more exciting because we can actually look at 2 cases related to the use of commas where it's actually meant a big deal for the parties in terms of the litigation outcome. So we start to see how important that precision is, and hopefully you'll then feel like it's an important step in the learning process to make you a good drafter.
Yeah.
I mean, just touching base on, you've been a barrister with such draftings, and there is issues like you said with commas, for instance, and goes to court and they argue over that. How do they resolve these sort of issues? I mean, I meant this instead of this kind of thing because of that comma.
Yeah, I mean, look, the court always focuses on the grammar because you can't adduce evidence when it comes to contracts of what the parties intended. It's the objective reading of the contract. Occasionally, as in the Canadian comma case, you can look at draft versions or alternative language versions. So there was French and English. But generally it's just as it's written, and the court will interpret it in accordance with the grammatical principles. So, I mean, that's your answer, and that's the answer that you give the client when you're advising them in litigation that they're likely to lose because the grammatical construction of the sentence isn't in their favor. Having said that, the vast majority of cases do not proceed to court. They mediate and they reach a settlement. So, it's unrealistic to say that these interpretation issues don't arise frequently because there's only a few cases on that. They probably arise a lot more frequently, but they get resolved by way of ADR. Yeah. Where we do see more litigation about grammatical arrangement of the words is actually in the interpretation of statutes. So we see more litigation about that than we do in terms of contracts. But that doesn't mean that they're not happening behind the scenes. And so, your interpretation of a contract and your drafting of a contract are still really important for the client because, one, they don't want to end up in a dispute with the other party to the contract anyway. So you want to avoid that at all costs. But in the event that you do enter into a dispute, it's still relevant to your advice in the settlement. If the grammatical construction of the sentence favors your client, you're going to push for a much better settlement of the dispute. But the other thing to note as well is just in practice is that quite often parties are pragmatic about the the outcome of the litigation that they're pursuing when they settle. So, you know, I've had clients who have, rather than settle for a monetary amount for breach of contract, because they want to continue trading with each other on particular terms, they might agree that, for example, the manufacturer might send a shipment at a discounted price. So they say, okay, the next shipment's going to be at a discounted price rather than us paying you a lump sum of X amount. So there's a lot of practical or pragmatic aspects of negotiation that, again, don't really reflect the issues in the drafting and who would have won in court, etc.
Yeah, that makes sense.
Okay. Any other questions?
No, I'm fine.
No.
Okay, well, thank you all again for attending, and I look forward to seeing you next week. We've got some interesting stuff to discuss in relation to the Canadian Common Case. It may take you a couple of times to get your head around it. Don't worry, it does take a while. If you really struggle with it, don't panic. I will be going through it comma by comma next week. Okay. All right, so I will sign off and I'll see you next week. Have a good week, everyone.
You too.
Bye.